what are the most common kinds of social media defamation issues you deal with, and how does dealing with your defamation problems relate to kind of Yelp's trust and safety model of protecting its users and engaging in content moderation?
Yeah, thank you for the question. So one of Yelp's core values since its founding in 2004 has been to protect the source. And what that means for us is we want to take steps to protect the users who contribute their user-generated content to Yelp where we can. And where that manifests itself in defamation is a lot of people know that you go to Yelp to read restaurant reviews, but we also maintain pages for pretty much any business that has a brick and mortar address. So you can go onto Yelp and review your local courthouse, your local Social Security Administration office. Anything that you can walk into, you can review on Yelp. And the lion's share of what I deal with on a day-to-day basis comes from disgruntled businesses or disgruntled actors out in the community who are upset with some user-generated content on Yelp. And that's where Section 230, to your comments earlier in the keynote address, really come into play and help us. And you made mention of the Gonzalez versus Google case that's currently before the Supreme Court. They had oral arguments a couple of weeks ago now. Just briefly, by way of background of the case, it starts in tragedy with the terrorist attacks in Paris in the mid-2010s. The ISIS state claimed responsibility for those attacks, and there was an exchange student who was killed, and her parents sued Google because of YouTube videos that were put up by ISIS and that allowed folks who were viewing some videos to see those as recommendations, thumbnail recommendations at the bottom of the YouTube page. And their theory of the case is that YouTube is aiding and abetting the recruitment of terrorists. YouTube and Google relied on Section 230 in the defense of that case, and the Ninth Circuit said, yes, Section 230 applies, YouTube and Google are immune. The question presented, at least initially in the Supreme Court, was if you make a targeted recommendation, if you as a platform make a targeted recommendation, does that take you outside the ambit of the immunity that's provided by Section 231C1? And so that's the question presented. And where it's of interest to Yelp is we do targeted recommendations every day. The way you review on Yelp is we have a page of reviews that we call recommended reviews, and we have a page on Yelp that's for non-recommended reviews. And that's based, there's software that runs in the background, and it's based on judgments that the software makes about how trustworthy the review is. And what it allows Yelp and other platforms to do is basically curate all the information that's provided by other users in a way that makes sure we're insulated from liability for whatever the content of that review might be. And I should have said this at the outset, so let me say it now. The views I'm expressing today are my own, and they do not necessarily reflect the reviews of Yelp. Having said that, I think the issue that you actually previewed pretty well with the Supreme Court is once they got that case, they couldn't figure out really where to draw the line, right? And we actually submitted an amicus brief pointing out that if you take away immunity for recommendations, there's really no sort of objective way to draw that line without making all sorts of liability judgment calls that heretofore are immune. So for example, in the newspaper, if something's on the first page, a creative plaintiff could say that's a recommendation that this content is newsworthy in a way that something on the back page or in a separate section isn't. And what Section 230 provides is that any user or provider of an interactive computer service shouldn't be treated as the speaker or the publisher of information that's provided by another user. And so there are two ramifications for that I think are worth noting. The first is it's not just platform immunity. It's immunity for other users. So if you retweet something that something else says, if you like something on Twitter that somebody else says, you can't be held liable for the content of that information if it's later found to be defamatory. who is the actual speaker, the person who actually posted that content on Twitter in the first place. The second thing is, it's really not a protection for big tech. What it's a protection for is the smaller companies who either can't afford the assurance that was discussed in a previous panel, or whose retention on their insurance policies is sky high because they're a startup company. There is a reason why Facebook, for example, is publicly in support of what they call Section 230 reform, right? Because they know that that will preference them, not the smaller tech companies. And then the last thing I would say is there is a legitimate concern that certain companies have grown to be too big, and that Section 230 is sort of a convenient cudgel to say we should take that away because it's protection that no other companies have. But the internet is different, and there are other legal tools that can be brought to bring those companies to heel. So we're publicly supportive of the antitrust effort against Google. We've given testimony in the case that relates to local search. And just very briefly on that, what that case involves is that Google is self-preferencing its own content when you search for certain stuff on the internet using Google. And my position is that Google has to kind of pick a lane. It can either be the world's organizer of the information provided, so it's a true search engine, or it can be a content provider, but it can't do both and then preference its own content ahead of TripAdvisor or Yelp or anybody else who contributes content to the internet. And I think that those tools, in my view, again, those tools are better addressed to kind of rein in big tech than to take away the protections that are really fundamental to the internet. Because the internet is different from other mediums. It just is. Most platforms rely on user-generated content, and they can't be in a position to pre-screen. The notion that you raised during your keynote about notice and takedown procedures is interesting, but there is an example of that now that is being abused.
DMCA.
Yes, the Digital Millennium Copyright Act. A lot of plaintiffs who know they couldn't otherwise bring a defamation case against a particular internet user will now try and send a DMCA notices, which is a provision of the Copyright Act that says you can send a notice to a platform that prior to the notice wasn't aware that something on the platform was subject to a copyright, and they will take it down. And what we're seeing now is folks saying, I own this copyright, when they may not own a copyright, or there might be a clear fair use defense to the publication of the copyright, and saying, take it down. And so even in the notice and abuse, or the notice and takedown procedures that we have now, there's some evidence that that's being abused to support this notion of kind of libel bullying that you described earlier. So that, in a nutshell, is my defense of big tech.
Okay, Frank. So in terms of republication on the internet or on social media, it becomes so easy to republish the content of others. Mm-hmm. What other implications does that have besides the ones we've just discussed? How is the law adapted to republication issues, and how have they adapted to this question of whether your influencer on Instagram is a public figure?
Boy, it is such a bundle of uncertainties. Right? The short answer is not terribly well. Thank you. I'm done. Yeah, no, I mean, by fits and starts is how the law has adapted. You know, when you think about the era in which all of these tools were created, right? The Sullivan case, the Gertz v. Robert Welch, all these other kind of seminal cases around the law of libel, they're all at this much simpler time, pre-internet, pre-social media, when we sort of had a common understanding of what it meant to be famous, right? You know, who was famous at the time of these cases? Well, Alan Alda was. He was on MASH, right? Carol O'Connor was. He was on All in the Family. Like, we knew who celebrities were. But now it's not that uncommon to go online, go to a site like Daily Beast or Huffington Post that covers kind of pop culture, and you'll see a headline that's something like, TikTok star dies in tragic boating accident. And my first reaction to those is, what? It's possible to be a star on a platform where you dance for 15 seconds to music? This is a thing? And the answer is yeah, right? That like there are all denominations of fame now, and we have many publics, right? We have many publics, we have many audiences. As recently as 1980, if you looked at like TV viewership, right? As recently as 1980, during prime time, everybody who had their television on, 90% of them were watching ABC, NBC, or CBS in 1980, and that's down to 30% now. And so it used to be, again, that we knew who was famous, right? You were on ABC, you're on NBC, you're on CBS. Those are who the famous people were. But now you could be famous on TikTok. You could be famous on Instagram, right? You could be famous certainly on YouTube. Entire fortunes have been built right around YouTube fame that sometimes jumps the fence, like Justin Bieber did, from YouTube fame into real life fame, right? And so I think that that doctrinal adaptation is going to be kind of clunky. You're going to hear some gears grinding as they shift because there is really no, the toolbox that judges have been given is kind of bereft of tools right now. You go to Home Depot, you bring a toolbox back, and you open up the toolbox, and there's nothing in it but a hammer and a Phillips head screwdriver, right? And it's like, I kind of really needed a socket wrench to get this thing open, but I guess I could wail on it with a hammer long enough, and maybe it'll open, right? And that's what judges are doing, right? They're sort of pounding on it with a hammer because it's the only tool the court has given them. And right now, right, the courts have given them two types of public figure, right? They've given them the general purpose public figure of the sort that grows out of the New York Times v. Sullivan doctrine, the idea that somebody who has such pervasive fame that they are able to influence public opinion. And then on the other hand, there's the limited purpose public figure that we talked about, and the kind of touchstone for that, the understanding, at least from the Supreme Court, has been that in order to qualify for that limited purpose public figure designation, you have to have interjected yourself voluntarily into the vortex of some public controversy, right? Those are the buzzwords that the court gave us. So think about the TikToker. Think about the Instagram celebrity. Do those people qualify under either of those standards, right? They're certainly not pervasively famous. They're certainly not Alan Alda. They're not movie stars. They're not sports NFL stars, right? On the other hand, they also, could one say that they've interjected themselves into a public controversy by trying to sell skincare products, right? I'm not entirely sure that we have the right vocabulary to talk about what it means to be Instagram famous or TikTok famous now that it is possible, right, to build niche fame that does enable you to influence public opinion for a subset of the public, a subset that may be a rabid following, but is small nonetheless, and not pervasive fame of the sort that would render you a general purpose public figure. And the scenario that I'm envisioning where something like this might come up, right, is so you've got your, all right, so I'm going to ask this question of the law students in the audience. How many people here have a presence on Instagram of the law students? Yeah. Okay. Well, when I was teaching journalism, you'll appreciate this at Florida. I assigned an exam question of a group of about 175 journalism students, and it had to do with one of the questions had to do with Instagram. And out of that 175 students, I'm not kidding you, I got back easily 10% of the people who wrote the exam said, well, as an Instagram influencer myself, ... Wow. That's that. Right? So the toolkit, like I said, I think is sort of inadequate to the moment, and so judges are going to struggle to adapt to this. But the scenario I'm envisioning, right, is so that person who has built a following on Instagram, right, and has done so in a very mindful way so as to cultivate an audience and to put content out there in the same way that in an earlier day people would do on radio or television, put content out there with the express purpose of getting people, let's say, to buy skincare products, right? And so someone comes in to the social media environment and posts something arguably defamatory about the influencer, right? Do not believe Alexandra when she tells you to buy these skincare products. She is a known fraud artist. She has a long history of committing fraud. Right? Fabricated, made up, fictitious, fake, right? Does Alexandra have a defamation claim? And if so, under what legal standard, right? Certainly, right, I think under traditional doctrine, leaving Instagram aside, right, if you say, well, has she interjected herself into a public controversy? The courts are not of one mind on this, that is commercial activity alone, sort of per se, a matter of public controversy. Some say yes, some say no. And then you go back to, right, for the law students in the room, I always sort of encourage people, well, go back to policy, right? Go back to, like, why does this rule exist? Why do these standards exist? And so what the Supreme Court has told us traditionally, right, is that there's kind of two foundational policy reasons behind why it's fair to hold that limited purpose public figure to a higher standard. And reason number one is what they call access to media, right? That this person has the ability to rehabilitate their own reputation and to defend themselves. And the other is this idea that they've sort of held themselves out and invited a critique of themselves, right? That, like, by engaging in the discourse, you kind of put yourself out there, at least for purposes of commenting on the reason for which you are well known, right? And I think that under those doctrines, that the idea that that Instagrammer with the, 50,000 followers is a limited purpose public figure can actually be an okay fit, right? Like, well, is it true that the person has access to media? Undoubtedly, right? That's why they're famous. And is it true that the person has put themselves out there and invited comment? Well, that's the functionality of social media, right? The whole interactivity of social media is built to invite comment, is built to invite discourse, is built to say, right? And in fact, they thrive on it to a great extent, right? Great dress, Alexandra. Your skin looks amazing, your hair looks amazing, right? The interactivity is what drives the audience up, right? What makes you valuable as a marketer, as an endorser, right? Is, well, look at this audience engagement that you have, right? And so under those kind of policies, I think that there's every reason to think that limited purpose public figure might be a fit. But last point on that, and then I'll wrap up, is what makes this interesting, I think, doctrinally, and different from, because the case that I mentioned earlier, that's kind of the seminal case where the Supreme Court starts us down the path of recognizing the limited purpose public figure, is the Wally Butts case that involves a guy who's a football coach at the University of Georgia, right? So Wally Butts, right, is famous for what? For being a football coach. He's famous for kind of performing that job. And he certainly didn't embark upon coaching football so as to obtain fame, right? I mean, that was a byproduct of it, but that wasn't the primary purpose for which he obtained the job of football coach. But you obtain the job of Instagram influencer, to the extent that's a job, for that express purpose, right? And for no other purpose than to obtain public recognition, right? It's the whole point. But what makes this so interesting is that there's speech on both sides of the transaction, right? And so it's different from, like, well, Wally Butts, right, was not being sort of critiqued for what he said. He was being critiqued for how he performed his coaching job. Whereas the Instagram influencer is pure speech, right? Everything that person is doing is speech. And so getting back to first principles in policy, if our goal in First Amendment law is always to sort of favor the resolution that gives us more speech rather than less speech, the resolution that encourages that participation in the marketplace of discourse, right? What direction does that policy point when you have speakers on both sides of the transaction? And I think people could vigorously disagree about that, right? Well, maybe we want to protect the influencer, right? Maybe we want to encourage that person to engage in the speech. And so maybe the law should be protective of that speaker and not sort of calculated to cause her to silence herself. On the other hand, right, we also want to protect the critic. We want to protect that person. Maybe a person has valuable information about the fraud that they want to share. And so I think that's just what makes this kind of a tough doctrinal question, and one that will no doubt be the question that launched 1,000 law reviews.
So I have saved some of my favorite questions for you, Jasmine, and I am so interested in this. I'm so glad you're at Florida, so maybe we could have even further conversations when we get home. But so I know. Let me just ask you two things. I know you've written about the concentration of power in platforms, and I'm kind of interested to hear your view on how that intersects with James' comments about concentrated power, and even within, tech platform liability might vary given the big tech problem. And then, but the other question I'm super interested in right now, and it's going to be a big problem for the restatement, is what do we do about defamation by algorithm and chat GPT? And what is chat GPT going to do to defamation law? I saved the hardest question for last.
Well, to the first question, thinking of what a platform is. We could back up even further, right? So we've spoken a little bit about Section 230 today, and that's where we are when we need to talk about the power of platforms, platform immunity. I would say, though, it's important to remember that Section 230 started out as a modest claim. It started out as a modest claim for interactive media or interactive computer services providers, right? It's called the Good Samaritan privilege, right? A modest claim, like, look, we understand you're gonna try to moderate. We understand that you cannot be responsible or held responsible for the, at that time, maybe hundreds of thousands of comments and things that were being done on your platform. And so we're gonna have this modest claim for you to not be held liable as an intermediary, right? You didn't do it, you shouldn't be responsible for it. And the plaintiffs, you may have a valid defamation claim or other claim, quite frankly, but you need to go after the people who did the thing or said the thing, quite frankly. And service providers, okay, we're going to understand, and we also want you to innovate in ways of making your platform safe in various ways, safe against defamation, safe against child pornography and other obscenity and other things, right? But Section 230, as part of the larger scheme of the CDA, is important as well, because we look at Reno, in the Reno case, it's important to look at the time how the internet was thought of, right? So this is the advent of the commercial internet, right? We're just getting a whole lot more people on the internet commercially, bulletin boards and chatting and all those things, a wide swath of people. But how the justices viewed the internet, if you go back and read that case, you'll be like, really? This is what we thought the internet was back then? Tubes and, But that's important because the characterization of the internet back then is how we're still interpreting the internet right now, and that does not exist anymore. A platform is not that Tubes internet that how the justices constructed it back in the day. A platform is more of a walled garden instead of this wide open space where anyone can come in and do whatever. Now, people can come into different spaces and do a whole lot of different things, and we've seen that, but it is not just this wide open panacea public forum that people constructed as and how people interpret it to get more privilege as a intermediary. And I think that's really important. Platform and internet are not the same thing. You cannot do the same things on a platform as you can on the internet, whatever that means. And so thinking about the concentration of power, how a platform can decide what happens, who can be on it, what are the rules and regulations, are really important. And of course we talked about Yelp being a smaller space, a smaller platform, but there are those larger ones as well that can control a lot of speech. And forgive me for having to kind of agree with Justice Thomas. In Biden, first it was Trump versus Knight Institute, and then it was Biden versus Knight Institute, and they basically kicked the case, right? Oh, we don't have to decide this because he ain't president no more. But Thomas, writing for himself, says, we can't keep thinking of platforms as these public forums. Public forums are kind of controlled by the government. We don't have control over Twitter. We don't have control over Facebook. A politician can get kicked off of these channels. What does that mean then for these spaces that we're trying to offer regulation for, but that space can say, government, get out of here, or government figures anyway, get out of here. You don't belong here, or this is not how we want to run the space. So I think it's really important to think about how power is really concentrated, not in the internet, but in these walled spaces. Replatformization, right, of spaces that exclude people, that are bent in certain ways. We saw that with Twitter on both sides, right? Or many sides, I should say. And of course, we're thinking of this from a very US-centric point of view, but the consequences for other countries and other spaces are really important also as we think about free expression as a global phenomena and having global implications. So we think about then a technology like ChatGPT, which is connected to a larger organization. It's important to think about what is the power inherent in a technology that people are kind of touting as being, wow, look at this generative technology. And at the same time, other folks are like, oh my God, what have we unleashed? And then what are the consequences, right? Who's gonna be liable when ChatGPT gets it wrong, which it has done already? But has it risen to the level of a defamatory statement, I guess, would be the question. I'm sure it'll come sooner or later. Someone will say, this is having negative consequences on me, on my history, right? Or how people look at me. The question is, are we gonna look at the power behind a technology like this, an algorithmic technology that's not just a small thing, it is a huge thing. It can reach a lot of different people. So if we look at the publication requirement for defamation, ChatGPT, with the power of the organization behind it, can reach so many millions of eyeballs, so to speak. What is the consequences of sharing a wrong statement from ChatGPT? So I would also want to point out that we have, with defamation law, but I want to scope it out broader, with technology in general, we have a generativity problem in the United States, and that is, if we can say a technology and innovation is generative, we're more likely to be like, oh, we should allow it to, do its thing for a while and then see what happens. That is perhaps not the best way to go. Like, let's watch and see. Let's watch and see what students do with ChatGPT.
I think that's the plot of Jurassic Park.
Yes, exactly. And we know how that turned out, right? So generativity, right? So kind of the, I would say, Lessig, Zittrain, even Wu kind of ideas about technology. If we help technology, if we help organizations who innovate and use technology, we can get some really good stuff out. And it's also one of the rationales behind, I think, a broad interpretation going back to Section 230, and that is, if we allow organizations to innovate, then we'll get something beautiful. Like the internet and speech and openness is beautiful. Ignoring the fact that there are huge consequences to a lot of the speech and a lot of the behavior that happens on the internet or platforms, right? So we have to have a really, I think, more sober view of allowing broad interpretations of law, but also hands off with respect to these generative technologies that are having and will have consequences on how people can recover or may recover with respect to defamation, but other kinds of harms as well.
Could I jump in for just a sec on
Yes.
ChatGPT? Because I was thinking about this a lot. And I think that the recent spate of news stories about the unreliable results that ChatGPT is prone to produce is actually really legally consequential for this reason. Because if you think about, again, trying to make this fit into existing constructs and doctrines that we have, right? So I sort of think of ChatGPT GPT legally in the same way I would think about commissioning a piece from a freelance writer, right? That like I'm the publication and I'm going to kind of offload this onto ChatGPT instead of a freelancer, right? Well, so if there was a freelancer who was widely known to produce inaccurate stories, right? And I commissioned the story from the known unreliable freelancer, that's on me, right? That's all kinds of malice there. And so I do think, right, that like the fact that the more that people report on getting these kind of, erroneous results or inaccurate or incomplete results out of ChatGPT, the more that people publish it at their peril.
Frank, would you think of them as a freelancer, or would you think of them as an employee? I mean, so which has, right, different consequences.
Yeah, I mean, if you commission it from a freelancer, then at that point, like for sort of 230 immunity purposes, I think, right? I mean, it's not an unrelated third party anymore, right? I mean, 230 is about the person who walks up to Yelp and, without having been instructed by you to do it, hangs their comment on your website, right? And so if I tell the freelancer, this is the story I want, and this is how much I can pay you for it, right? I don't think it matters whether I call them an employee or not, but.
Yeah, I'd like to jump in too, if I just could, on the ChatGPT point, because I, maybe it's just my simple caveman lawyer, but I don't think it's that hard to reconcile with Section 230, because the language of Section 230 says you're not immune if, in whole or in part, you've created or developed the information that is at issue, right? And so I think there's a very reasonable argument that both the person who provides the prompt and ChatGPT as artificial intelligence have created or developed the information in whole or in part. And I think that is categorically different from what we traditionally think of as platforms or other users who are just providing the tubes in Reno speak to allow other users to express their point of view. Certainly the case law needs to be developed, but I think there is an answer that reconciles this idea of maintaining immunity for kind of true platforms or true other users, but also allows space for lawsuits to proceed against ChatGPT outputs.
Well, I have a question for you along those lines. You probably know a case called Seaton versus TripAdvisor. And so it ties into the ChatGPT stuff. We're acting like it's utterly new, but there is some precedent for what if an algorithm aggregates this. In this case, the algorithm, it was TripAdvisor's algorithm, and it said these are the 10 dirtiest hotels in America. And this one was in Tennessee. Was it in Murfreesboro?
I don't know exactly.
Anyway,
I'll take your word for it.
But the way they designated which was one of the 10 dirtiest hotels in America was the algorithm took the comments and they aggregated them through the comments. And the court branded that a form of opinion, that the algorithm had created an opinion and therefore it couldn't be defamatory because it was non-factual opinion. So that's an early algorithmic defamation case. Can that apply to ChatGPT?
Potentially. I mean, so we actually had a similar case where we relied on Section 230 immunity to defeat it, but the plaintiff's theory was that the aggregate star rating that you see on Yelp, which is a algorithmic function of users' individual reviews and their individual star ratings, could make Yelp liable. And we were able to successfully defeat that in the Northern District of California on the basis of Section 230, that all we were doing was aggregating the content that was provided by others. And I think, so when you talk about algorithms, it's really important to define what we mean by algorithms, and that's come up in a ton in all of the Gonzalez v. Google Amici briefing, because I don't think either the courts or, frankly, a lot of the Amici have a good handle on what an algorithm really is. It's really just a shortcut, if you think about it, right? Yeah. And so there isn't anything inherently speechy or content about the algorithm itself. It's a programmed shortcut. And so that's, the argument we make when we see cease and desist letters that are sent because some business has an aggregate 1-star rating and saying, hey, Section 230 doesn't apply to you because you've aggregated these star ratings for businesses. And I think that's how we've approached kind of the algorithm aspect of this, is if you're just thinking of it as what an algorithm truly is, it really doesn't change the analysis too much.
Right. How do you prove actual malice?
I mean, I'll step on this from an internet platform point of view. So another aspect we deal with a lot is subpoenas from disgruntled businesses who are unhappy with critical reviews where the reviewer has chosen to remain anonymous. So on Yelp, if you're a registered user, we encourage you to use your own name and post a picture of yourself when you're doing reviews. But we also allow for you to remain anonymous, particularly if you're reviewing a business that has some sensitivity to it, a doctor, a lawyer.
James, can I ask? I have a burning question I was going to ask, but this is the right place to ask it. I always tell my students that dentists seem to be the most litigious against bad reviews. Is that correct?
Yeah, I was speaking about this last night at dinner. So we see dentists. I think they're probably number 3 anecdotally. We see lawyers and we see plastic surgeons. Those are the 3 major categories of people who are really unhappy with Yelp reviews.
I'm going to teach better now.
But so the way actual malice and this notion of fault in generally plays in when we're dealing with these incoming subpoenas is we ignore it. Because so what we hold subpoenaing parties to is a Dendrite standard or a Highfields or Krinsky v. Doe in California standard, which basically boils down to you have to demonstrate that you have evidence on the prima facie elements of your defamation claim. So all those elements that were spoken about in earlier panels. And if you don't have that evidence, we're not going to produce that information to you, going back to that protect the source idea. And so we've made the judgment that in fairness, it's really not the subpoenaing parties, they don't have the ability to prove that a statement was made up to a certain fault level, reckless disregard or willfully lying or whatever, in the absence of knowing who the reviewer is. So in Yelp's case, we sort of just disregard that.
All I can think of is that the Venn diagram of people who think it's a good idea to spend $50,000 on a butt lift and people who think it's a good idea to pick your surgeon off of Yelp is a completely overlapping circle.
It's really been remarkable, the evolution of this law about subpoenas. And I remember back in the very early days in 2000, it was just beginning this tactic of weaponizing subpoenas for anonymous reviewers or anonymous speakers on the internet to chill their speech and chill their criticism. And the law, that was around 2000 that it picked up dramatically. And now 23 years on, we have developed a host of standards where we understand that it's so often weaponized, we have to have legal tools to deal with it. Do y'all foresee anything else that you see evolving in that way based on your research or based on what you're litigating right now or claims that are coming in?
So I would say that in the future we're going to see, you asked about actual malice, like how would you prove actual malice in an algorithmic defamation? There are a lot of attempts to require algorithmic audits for organizations. So if you are doing the auditing as you are supposed to, right, seeing how your system that you've created works, seeing some of the faults, seeing some of the biases that continue and how you perhaps could make them better or mitigate some of them, then that report could start to be used as evidence of, like, are you entertaining doubts about your system? And are you fixing it? So, like, if actual malice for a journalist or anyone else, quite frankly, is going into their mindset, what kind of proof of a mindset, right? So for the Dominion case, we're looking at evidence of emails, right? Like, oh, we kind of entertain doubts about what we're saying. But an algorithmic audit, internal audit, is basically could possibly say the same thing. Oh, we're kind of, this is not giving us what we want. Maybe it's giving us 60% of what we want, and we want to reach a different level. And then the next time, we still haven't made it better, but we're still going to continue to use it. So what kind of evidence is that for actual malice? It would seem like a similar thing. You're entertaining, or at least that what you're getting, the outputs are not that great, or not as great as you want them to be. So would that could possibly be used as evidence of liability? I would think so. And perhaps that's a rationale, not just for defamation, but it's perhaps a rationale why many policymakers are attempting to force algorithmic audits. Give us evidence that you are either trying to make stuff better or evidence that we can use to force you to do something, whether that's pay money or do something else.
So this is where I get a little nervous because with this idea of algorithmic audits, because take Google or YouTube, for example, there's a clear bias in their algorithm in the sense that what they're trying to do is drive traffic to their site, right? Drive clicks, drive additional traffic to their sites. And my concern from a speech regulation point of view is the government shouldn't be in the business of deciding what is too biased in one direction or the other, because the outcome of that is, frankly, the state scheme that we're seeing now, where Florida and Texas have passed these onerous social media laws that are being challenged in court right now and will probably come up in the Supreme Court the next term, that is putting a whole bunch of sort of non-deplatforming requirements onto internet companies. And then you have a statute that was passed in California on the complete opposite end of the ideological spectrum that is all about transparency. And at Yelp, we've done trust and safety reports for the last 3 or 4 years now, where we talk about what accounts we remove, what reviews we remove, and why, and we do that every year. Mm-hmm. So I think transparency by the platform is a good thing, but I'm not comfortable with this idea of the government doing these algorithmic audits to make a determination as to whether or not there's an inappropriate bias. Because at the end of the day, these companies have First Amendment rights too. And even if it is biased, I think they have a First Amendment right to be biased. So
not if Judge Oldham has his way in
exactly.
the Fifth Circuit in the Texas case. He says they're just censors.
And so when you sit here as a platform, if you will, and how do you comply with these laws, assuming they were constitutional, which obviously they're not, but you're not able to do that. And so to pick up on an earlier panel, the idea of like geo-blocking certain regions, we may come to a point where a platform decides it's too expensive to be available in Texas. So if you're communicating with us from a Texas IP address, we're going to block you.
Two quick thoughts in building on that. So your discussion of A, that policymakers don't necessarily understand algorithms, and B, this idea of algorithmic neutrality, right, came up front and center in the oral arguments in the Google YouTube case, right? That was like right out of the box. The counsel for the bereaved family, the appellant's counsel, right out of the box gets jumped by Justice Thomas, who I'm sure that person was counting as the one hip pocket vote that they could count on, right? And gets jumped, essentially saying, why did we even take this case at all? Which I think lots of people were wondering, right? But the question that's presented is, well, isn't this just a quote unquote neutral algorithm? Like the sort of theory of the case was, right, that YouTube is responsible for having served this person increasingly radicalizing content by way of their recommendations, right? That like you've departed from your role as just a series of tubes because you are now preferencing and prioritizing certain content that you have selected using your editorial judgment, right? But I think that the kind of undertone to that comment was that if there was proof that it was not the same algorithm, right? The question was, well, isn't this the same algorithm that would also recommend, I like videos about cats or real estate or whatever? And the answer was, yeah, it's the same algorithm, right? And but the clear implication under that was that if it wasn't the same, that the court might be prepared to say, well, in that case, you have sort of a selective terrorism algorithm here, and that we're going to hold you responsible for. I mean, they didn't quite go there, but I think there was at least a door open to that, right, to your point.
Yeah, go ahead.
Go ahead.
I picking up on that comment, I think the construct of neutrality, frankly, from a platform or defense point of view is mistaken. That it's not the neutrality of the algorithm, it's the uniformity of the algorithm that's important, right? Because from a plaintiff standpoint, you're always going to be able to successfully plead, particularly in state court where Iqbal and Twombly may not apply, that algorithm is non-neutral. We've all agreed that the YouTube and Google algorithms are designed to increase clicks, increase views on the platform. From Yelp's point of view, the recommendation software that we run on reviews isn't neutral in the sense that if there is indication that this is a one-time review and we don't have other indication that the review is trustworthy, we're going to put it on the non-recommended page. It's still accessible, it's just on the non-recommended page. So I think, in general, platforms do themselves a disservice when they rely on this idea of neutrality in their algorithm as opposed to uniformity.
You know, Jasmine, you raised something, and I think is a theme that's carried throughout the day, and it's and your comments raised it too, is maybe antitrust is the better vehicle, which I've always thought was the case myself, although I have a former colleague at Mizzou who would an antitrust scholar who would dispute that. But which body of law is the right body of law? Do we want this done by legislators? Do we want it done by courts? Do we want self-regulation? Do we want it to be tort law? Do we want it to be federal? Do we want it to be state? Like where is the right point of entry? And is there a similar answer across these questions, or is it a case-by-case kind of thing?
Yeah.
I'm sorry, I've thrown you all the hard questions.
Yeah, I don't think it should be a state-by-state thing. And I say this as a privacy law person too,
Yeah.
with the rise of like several states, in absence of a federal omnibus data protection or privacy law, taking up the mantle of saying we need to do something about what's happening with respect to, but it's too many different things happening all at once. And that never works out in the manner that we want it to work out. And it certainly doesn't protect all the different people within the United States that are being harmed perhaps by what the law is designed to protect people from. So I don't think having, at least 50 different laws related to this will work out in the way that we want it to work out. I think, yikes. It's good. One of the things that would be really important for Congress people to think about is what are the goals of a uniform law related to these topics? Like, is it harm reduction or mitigation? Is it innovation? Is it antitrust? Is it all of the above? And could you possibly create a law that gets to all of those things all at once? I don't think so. One of the things I think that is important to talk about also, we talk about algorithms and we talk about speech and possibly defamation, is the kind of expression we're talking about. So are we talking about always social and political, or are we knocked down a level to commercial and something else? Because we know that those don't get the same level of protection. And since they don't get the same level of protection, we need to start talking about what we could possibly do with commercial speech, that dough-making, that money-making speech, that we can't do with social and political. And what are the things that we're gonna classify now as social and political, or are we going to say it's mixed, right? So I can get on my TikTok, not that I have a TikTok, but whatever. I can get on my TikTok. I can get on my TikTok and dance, but also in the background have a Black Lives Matter sticker. Is that social political speech? Like, am I making a commentary? Am I making a statement about what I think is important, but also making sure that because I played that snippet of a song that people are going to watch it, and therefore I might get invited to the TikTok creators, whatever it is, so I can make money, a little bit of money or whatever. Can I become an influencer related to political and social things, and then am I in the realm of solely political speech, or am I also in the commercial? And so like, what needs to happen with respect to that? And then if we're talking about it's the speech of the platform, is the platform as a corporate entity in relation to certain things, is it always going to be a political or social speech thing? Or again, are we going to start looking at some of the regulations or the frameworks we have for commercial speech, which again, the law says in the United States that we can regulate, it's robust. Like if you say a platform can't do something, it'll find another way to do something. Like that's just what it does. It's a money-making venture. It may be more difficult for smaller platforms, startups to get into the realm, and that's something we need to critically consider as well. But is it the same as what we vaunted as the social and political, when it's really about how can I get you to purchase a good or a service, or how can I get you to pay a lot of attention and waste time because I want to collect your data and see what you are and then categorize you and then sell that to third parties. So when we're talking about speech, it's not analogous to a newspaper. It's not analogous to the traditional forms of media that we think about. And I think that's really important. We talked earlier about maybe judges and maybe legislators don't understand what is actually happening with respect to technology. It is not, there are some aspects that are newspaper-ish. There are some aspects that are broadcast-ish, but it is a totally different beast. And we need to recognize that, and all of the things that are on the backside that make it significantly different, and therefore it needs a significantly different framework or set of frameworks with respect to regulation.
Frank, what do you have? In whom do you have confidence as a regulator?
I think I'm supposed to say, because I'm a First Amendment guy, the marketplace, of course. No, but to this point, and we could have a whole nother symposium next year about this subject, but I really think that this, you're touching on a really huge point about sort of what does it mean to address a matter of social and political concern, again, in the 23rd century when we have so many publics, right? And when something that I think is really worth the sort of junior scholars in the audience here thinking about and exploring is, well, so many people now live their lives online more or as much as they live their lives in the city of Columbia, right? And to many people, like Twitch users is their community, right? The gamers that I spend all of my evenings interacting with, right? That is my community much more than the city of Columbia is. And so for those people, like whether there is a glitch in the latest release of a video game is of more or as much civic concern as what the city council voted on in Columbia last night, right? And so I think that this kind of like the rise of multiple online subcultures just explodes our idea of what we've always thought of as a matter of social or political concern.
That's just my son is a nationally ranked Magic player featured on Twitch. Yep. So just to confirm your point, which was not a thing that could happen, 20 years ago. But when in high school, when your high school age son says, "I want to be a professional Magic player," and that's his career ambition, and of course you poo-poo that, and then he has another career. He's an actuary by day, nationally ranked Magic player by night. But I do worry about this problem of our regulators understanding the technology. As you said, they don't really necessarily understand algorithms. I remember back in the day in 2001, I went down to a hearing to try to convince a judge that they shouldn't uncover the identity of a John Doe who had been sued for defamation online because it was a frivolous lawsuit designed to weaponize and silence the critic online. And the judge said at the hearing, I don't understand all this message board stuff. I can't even check my email. My assistant does that for me. And I was like, oh my God, I'm gonna lose. But I worry, like the justices have gotten much more hip and with it than I expected them to be. But as Justice Kagan said, the 9 of us are not the experts on the internet. That's what she said in the Gonzalez hearing. So what do we do when there's a need for regulation, but the knowledge needed to apply the law, to apply the law to the phenomenon is not there? What do we do about that?
Yeah, I'll just start. I think there is a reason why the court has, up until now, they're about to decide number 5, but up until now, they've decided 4 cases that involve social media in the history of the United States Supreme Court. And by the way, all 4 have gone in favor of the speaker. Speakers are 4-0 in those cases, but fun fact. But there is a reason why they have proceeded with great hesitation, and why I sort of distrust all of the branches of government to get it right is because the target is moving so rapidly, right? I mean, the reality is that, like, newspapers in 1980 looked a lot like newspapers in 1960 and 1950, but social media in 2023 looks not at all like social media did in 2008, right? And so our generations have gotten smaller, right? And it's like, iPhone 13, iPhone 14, right? Our generations have gotten compressed. And for that reason, it's just really perilous to write any rules in concrete. I mean, so I'll give you a very, very a practical example of this. So when I first started litigating in this area and representing kids who were like brought up on disciplinary charges for what they put on social media, right? We used to be able to say, think about how quaint this sounds today. We used to be able to say, well, come on now, social media is entirely off campus, and in fact, it's blocked on the school computers, and so no one is looking at social media on campus, and so why would the school have any jurisdiction at all over Facebook or Twitter? Because you can't even look at it until you leave the building for the day, right? And we could say that with a straight face a few years ago, but right now, that's a laugh line now. That's a punchline, right? And so for that reason, I just think that like any kind of categorical rule that either the Supreme Court, I mean, court's trying to decide things that will last for 50 years, right? And there's just no way that they're going to be able to do anything other than just the highest level of generality, right? Or will coin some guiding principles for you. And I think that's their proper role.
Can we turn it over to the audience for questions now?
Yeah.
For you students in the audience, there will be jobs.
This is for James. So we were told earlier today that Twitter users wouldn't have to worry about being sued because they don't have any money. But then you mentioned subpoenas all the subpoenas that are coming up. The subpoenas, of course, are to these anonymous users. And so, like, to make it more concrete, does a blue checkmark Twitter user have to worry about calling Donald Trump a Cheeto if, like, defamation law gets changed?
Yeah, I mean, so when these folks are suing these anonymous, for Yelp reviewers for Twitter, and based on tweets, it's not to collect money, but it is to potentially get an injunction. Once they name the person, they can serve the person or substitute serve them. A lot of times the defendant won't show up, particularly if the lawsuit is brought somewhere they are not. And then the plaintiff will get a default judgment. And then they'll come back to the platform, somebody like Yelp, and say, we got a judgment against this user, it's defamatory, take it down. And so what our policy is on that is, obviously we don't want defamation on the site, but if you just go get a default judgment, where the judge has not specified what in a review is defamatory and why, we leave it up. And we rely on our Section 230 immunity to do that. So I think the sort of the anonymous user is at some risk, not because they're going to, at the end of the day, pay a whole bunch of money, but because they're going to have this injunction issued against them. And it's just really scary to be sued, right? If you're not familiar with the process and you know it's going to cost money. And I'll just give one more shout out to what other panelists have said earlier today, how important anti-SLAPP protections are. I'm in favor of a federal anti-SLAPP law because what it does in addition to a whole host of other things is stay discovery. So a lot of those costs can be deferred until the plaintiff comes forward and says, despite this being an issue of public concern in a public forum, I can prove my case because of reasons A, B, and C. And so I think anti-SLAPP is important, and I think platforms' willingness to go to bat for their users and say, we're not going to just hand over this stuff and we're not going to enforce rubber-stamped judgments is important.
This was a great panel. Thank you very much. Maybe as a potential ending here, what's your prediction? What's going to happen? What do you think the court's going to do? We know that about 2 of the justices, perhaps, but what do you all think? Loaded question, but what do you all think is going to happen?
Is it a Sullivan question? A Sullivan question
Google.
specifically?
I'm talking about the 230.
Oh,
Gonzalez.
Okay.
You want to start?
Yeah, I'll start. Based on the oral argument, I think they may, what do they call when it's improvidently granted? They whatever the denial of cert, they reverse the denial of cert as improvidently granted. I think there's a chance they could do that because I think their questioning revealed, ooh, we may have waded into the issue with a bad case as a vehicle to really consider whether 230 has been interpreted too broadly. And the other thing about using it in the Gonzalez versus Google is I'm sitting here as a torts professor thinking, well, you got a proximate cause problem.
Yeah.
You got a proximate cause problem. You don't even need to go to like 230. This case never should have gotten here in the first place. So I think they're not going to get rid of 230 in this case. They may do it somewhere in the future, but not this one.
Yeah.
Or limit it in this case. They're not going to get rid of it. They may limit it.
I tend to agree, and what my takeaway from listening to the oral argument was really that, I don't know if it was a dawning realization or just the expression of a realization that this is about more than just big tech, and that some of the questions that the justices asked, including Justice Thomas, I think reflected a realization of that.
That's good.
And so I tend to agree, but I'm certainly knocking on wood as I say that. I hope this is wood.
So I'm in agreement with everyone else here, but I think on the state level, I think there may be more social media targeted pieces of legislation that are floated that get it wrong or are unconstitutional, but they are attempts at regulating tech or social media sites in a way that Section 230 says no. And so to that, I think the feds, the federal Congress is going to have to actually weigh in. Well, like right now, there was a fervor like about Section 230 at Congress like 2 years ago during the pandemic, like the height of the pandemic. It's died down now, and hopefully they have other things to do
Yes.
or worry about right now with respect to that. But I think states might push the issue, like the things that are coming up from the states might push the issue in the on the federal side. So
Yeah, so if you listen to the arguments in both the Google YouTube case and then there was a Twitter case the very next day argued by the same appellants counsel, 100% of the Twitter oral argument questions were statutory construction and 0 were 230. And so that case clearly will not be decided on 230 grounds. And quite a few of the Google YouTube were not 230 questions either. So I think that Lyrissa is quite right that there's every chance that they could kick it on some ground that has nothing to do with 230 and never touch it at all, causation as one. Or just right, I mean, it's controversial to apply the assistance to terrorism statutes to people who do nothing but speak, right? And so like there's a lot of hurdles to get over for this claimant and a lot of places that they could trip short of implicating 230 at all. But these are just the appetizer course. The entree course is yet to be served. There are 2 companion cases that are about to be fully briefed called the net choice cases, right? One is out of Texas and one is out of Florida. And to Jasmine's point about all the activity now being at the state level, right? Both Texas and Florida legislatures passed legislation just exactly this, trying to kind of rein in the scope of or to get around 230 to say, you know, you can't deplatform people based on their political ideology, you can't pull down political speech at all, no matter what it says, and on, trying to kind of, you know, dictate what the platforms can carry. And there's this long tradition. There's a case called the Tornillo case out of Miami where the courts have held that, like to James's point, that, well, you know, platforms, in those days we call them newspapers, have First Amendment rights too, and part of the bundle of First Amendment rights they have is to decide what not to carry. And you can't compel them to carry content because that puts words in their mouth and attributes the speech to them, right? And so that, by that principle, these Texas and Florida statutes are in great tension with the Tornillo rule, and I think those, should the court grant cert, and there's every reason to think that they will, to evaluate the constitutionality of those statutes. That will tell us whether they have an appetite to rein in 230 or not. But ultimately, I mean, will policymakers do anything with it? I think that it's like what Churchill said about democracy, right? It's the worst system of government except for all the others. And I think that 230 is the worst system of internet governance except for all the others. And so to get a consensus in the House and Senate and White House on what a, quote, fix looks like is just, I can't envision it in my lifetime.
But to base it off of Tornillo, we would have to, again, analogize platforms to newspapers. What are you going to analogize this? Or are you going to like step out and say like, well, you know, this is a totally different thing, and it's not just this, and it kind of looks like this, but really it is this. And that's the important question. Like, can we continue to, I mean, precedent, it's important, the law students, it really is, but when the precedent doesn't match, when it doesn't provide the framework necessary, then there needs to be a difference made, right? So I think that's important to think about as well.
Well, I mean, interestingly enough, CDA 230 came because of a mismatch or a perceived mismatch of prior precedents between something like, is a platform's liability for defamation, should it be more like a bookstore's liability? Because bookstores are only liable once they're put on notice of defamatory content and fail to do something because they have no practical way to know the contents of all their books. Or is it more like a newspaper's liability? They're liable for the content of others that they publish in their newspaper. And then Congress maybe said in 230, none of the above, or maybe it said, no, they're not like newspapers, they're like bookstores. And so this reasoning by analogy in the context of, just to reiterate, in the context of something entirely new, it gives us fits as legal policymakers because we just don't know what to do with ourselves. Judge Oldham would say it's more like telephone companies, but Judge Oldham, or railroads. Judge Oldham in the Fifth Circuit case, in one of the net choice cases, there's a conflict between the two cases. One says the no content moderation policy that Florida tried to adopt is unconstitutional. Texas said the no content moderation policy it tried to impose on platforms is constitutional. And that what they used, the frame they used the word censor. They said big tech is a censor 131 times in the opinion. They didn't think they had any speech rights at all. They said they're just acting as a censor 131 times. So.
And then they initially refused to stay pending appeal.
Yeah.
Or
yeah.
writ, right?
Yeah. Yeah, it's a those net choice, if any mischief is going to come in, I don't think the mischief is going to come from Gonzalez. It's going to come from net choice.
Oh, one in the back.
Thank you, panelists, for being here. I've really enjoyed the discussion. My question is about deepfake technology. I presume as that technology is developed more and more, will perhaps be impossible, or at least very difficult to distinguish, a video of someone saying something and then a deepfake video of the same thing. So my question is, do you see defamation law is up to the job of dealing with that problem? And if not, do you have any policy proposals or ideas for addressing that? Thank you.
I think defamation could be a possibility. There's a couple of possibilities, but I think defamation could be. I think we've seen a similar thing happen with using defamation for when, if we're talking about deepfake videos, for example, when videos have been cut in certain ways to make it seem as though someone said something or didn't say something. There have been quite a few large cases. I believe, what's the Drudge case with the...
Sidney Blumenthal, is that the one?
The USDA woman who was at the USDA. And they cut the video to make it seem like she was a racist, basically. I'm not going to give white farmers any help.
Yeah, false editing. Yeah,
right.
Yeah, like
and so they edited.
Splice. Yeah.
Right. And so there have been several those kinds of cases. Again, if we're going to use an analogy, those might be the kinds of defamation cases that we would use. I would say that it is defamatory to make it seem as if someone said or engaged or did something that they didn't do that harms their reputation, like on the most basics of defamation law, and then to distribute it, right? And there be harm. So I think there is a possibility for defamation. There's also other like invasion of privacy related things. So again, I'm sorry for inserting privacy in here. It's just what I do. That we're talking about informational rights or rights about information. So defamation would be like the rights to have information that does not harm your reputation, that's false and negative. And privacy, it might be correct sometimes, but you want to be able to control it. So it's all in the spectrum of having information about you under some kind of control that you're not harmed by it necessarily. So I think that defamation and privacy will go hand in hand for deepfakes, to me.
What's interesting about it to me is how much of it boils down to what Frank was talking about earlier in terms of the categorization of limited public figure, because you can imagine a scenario. There was a deepfake of Tom Cruise going around, I don't know, maybe a year or two ago, and you can imagine somebody putting, some critique of Scientology in fake Tom Cruise's voice, and that would clearly be parody or satire, or, depending on the nature of the exact speech. But it would also be, I think, a question of actual malice as a public figure, and so as we see these deepfakes propagate, I think a lot of the analysis is going to bring us right back around to where we started in terms of figuring out what is actual malice, and is this person a public official, a public figure, a limited public figure, or other. So.
Yeah, there are like pre-technological analogs. I remember once there was a Photoshop picture of Hillary Clinton while she was running for something in like leather, like dominatrix attire. I had photoshopped onto a different body, and so that, that's clearly parody. But I think you could do some things with some transparency laws. There's some, the constitutionality of those. There's First Amendment protections against the government making you have certain transparency obligations, but it's not usually strict scrutiny that goes behind requiring transparency when it prevents consumer confusion or consumer deception. So maybe some regulatory fix for some of the problems, and including ChatGPT, could be some transparency obligations about this was created, this is not a real image, this is created, or this is not a real celebrity. And it goes back to what Jasmine said about commercial speech too, because some of the deepfake stuff is going to be commercial.
All right. Oh, you want one more question? All right. All right.
So you brought up privacy a couple times. With the recent overturning of Roe v. Wade, the right to privacy has come into a lot of question. If there were to be a constitutional amendment put into place that specifically outright puts out the right to privacy, how would defamation law be affected by that?
Oh, we're out of time. What a tough one.
I'm going to say it depends. and I'm serious.
It was a very speculatory question. That's fair.
Yeah.
The restatement is eventually going to get into the privacy torts in particular as well, all of these issues invade the privacy torts as well. Almost everything we've talked about is going to have to be considered at the privacy level as well, including what happens in a world where you don't really have as much privacy protection as you think, and you can always be found out, and you can your information can be subpoenaed, and for good reasons it can be given up. And I don't think it necessarily automatically that a constitutional amendment for an intimate right to privacy would necessarily have a big effect on defamation law as it currently stands. I do think, however, and this may be the genesis of your question in part, is the Dobbs free speech controversies, the non-defamation Dobbs free speech controversies are burgeoning now, and they're going to be like explosive and very interesting. So if you like this kind of stuff, there's lots to do coming up with the Dobbs free speech controversies. Also Commerce Clause and a bunch of other stuff too.
All right. Very good. Thanks, Lyrissa and our panelists.